I'm John Lonergan, a partner at the Lonergan Law Group Limited in Peoria, Illinois. In Illinois, a misdemeanor and a felony are determined by the potential penalties of a particular charge. Felonies all carry the possibility of penitentiary sentence. Misdemeanors, you can get jail time in the local county jail and fines. So misdemeanors in Illinois, there's three classifications. Class A is up to a year in jail, up to $2,500 in fines. A Class B misdemeanor is up to 180 days in jail, up to $1,500 in fines. A Class C is punishable by up to 30 days in jail and $1,500 in fines as well. In Illinois, misdemeanor classification is determined just by the legislature and how they've determined to classify certain types of behavior, such as shoplifting. That can be a misdemeanor. Unless it's over $500, then that can be a felony. Doesn't mean the prosecution's office will necessarily file it as a felony, but they have that ability to do so if they want to. In Illinois, you have an absolute right to a jury trial, whether it's a felony or a misdemeanor case. Any case where you're charged criminally, either as a felony or a misdemeanor, you have a right to a jury trial. And that jury trial right's important even if you don't go to trial, because it's the most powerful bargaining chip that you have in the course of negotiations, is your right to trial. A Class A misdemeanor is the most commonly charged misdemeanor. That can be a battery, shoplifting, or what we call retail theft, petty marijuana possession. The amounts have gone up since the law has changed in Illinois. Over 30 grams of marijuana will be a Class A misdemeanor now. The most common misdemeanor I deal with in Peoria is domestic battery and violations of order of protection. Those also fall in that. And as the legislature has judged conduct to be less severe, the classifications are reduced. A Class C misdemeanor, for instance, generally only encompasses one charge that we deal with regularly here, which is disorderly conduct, or sort of a more severe version of disturbing the peace. That's the Class C that we see most often. In Illinois, if you're convicted of any offense, whether it's a felony or misdemeanor, that offense cannot be expunged from your record. That's why it's very important to have an attorney guide you through the process so you know what those potential consequences are. Also in Illinois, if you have a misdemeanor conviction for certain types of offenses, if you're arrested again for a similar offense, that charge can then be elevated to a felony, even though the conduct itself is only a misdemeanor. A good example is retail theft or shoplifting. If you have a prior conviction for that and you are arrested and charged with retail theft a second time after that, that can automatically be a felony charge, even if it's just a pack of gum. That's well under the $500 limit. Another example is domestic battery or violation of an order of protection. If you're convicted of either of those offenses and you get a conviction for either of those offenses a second time, that can also be a felony. Doesn't mean it will be necessarily, but the prosecutors have that option if they choose to exercise it. I think that for a lot of people, they hear the word misdemeanor as opposed to a felony, and they think it's no big deal. It's just a misdemeanor. And that's true in a sense, but in a larger sense, it's very inaccurate in that even with a misdemeanor, you can spend up to a year in jail, and I don't think anyone thinks that's an acceptable penalty for a misdemeanor offense. In addition, a misdemeanor conviction can result in more serious charges if you're in the system again sometime down the road, and a conviction for a misdemeanor is something that sticks on your record permanently, and that can affect all manner of things that you may not have considered at the time, such as future job prospects. Most employers don't want to hire a felon, but there's many employers that don't want anyone with any sort of misdemeanor conviction on their record. So just that is an example of future prospects damaged because you thought that a misdemeanor was no big deal. So an experienced criminal defense attorney can help you navigate this entire process. They should explain to you what the court process is like, how the procedures are going to be handled. An experienced attorney can instruct you how to prepare for the case, things you might be able to do before the case is resolved that will help in that disposition at the end. I take great pride in educating my clients on the law and the potential consequences, short-term and long-term. Finally, it's my duty to advise my clients as to what course of action I think is best for them. Ultimately, that decision is my client's, but I'll always be honest and tell them what I believe the best course of action is. If my client decides to ignore that advice or take that advice, that's entirely up to them, and we'll proceed however that client decides they want to proceed. You can reach the Lonergan Law Group at 309-673-3939 or through our website, johnlonerganlaw.com.